case on the morning docket. 125879 in the matter of Kenneth Eland. As counsel are coming forward, I would explain Justice Wall's departure. Justice Wall is recused from the hearing of this case. And that means that he will not participate in the argument today or in our deliberations or decision-making. Mr. Ambrosio, you're welcome to take counsel table and
Thank you. Madam Chief Justice, Justices, Julia Hart, Deputy Disciplinary Administrator, appearing on behalf of the Office of the Disciplinary Administrator. I previously requested rebuttal time.
I have a note of 3 minutes. So.
Perfect, thank you. So this case today before the court is a case that arose from a docketed complaint alleging that the respondent violated the Kansas Rules of Professional Conduct and his representation of clients in a real estate transaction that began in 2015 and was ultimately concluded in 2020. Mr. Eland has a title office and a law office that are located in the same building, and the title office was initially contacted by a local realty company to retain their services to provide title assurances and insurance for a real estate action of property in Gove County, Kansas. The sellers wanted to separate the land and surface rights from the mineral rights and sell these interests separately in the sale in 2015. In a very summarized fashion, as far as why we are here today, the buyers who purchased the mineral rights in 2015 filed a complaint with the disciplinary administrator's office after Mr. Eland took 3 years after the closing date to provide a title opinion, and that the title opinion that he provided was not actually correct. This was a case that at the formal disciplinary hearing stage of the matter, the parties worked hard to determine where we had common ground and where we could agree on facts and rules violations. The parties did enter into a stipulation stipulating to a majority of the facts in the case. The parties also stipulated into rules violations, and we're in agreement going into the formal hearing that the respondent violated KRPC 1.1 competence, 1.3 diligence, 1.4 communication, 1.15 safekeeping property, 1.16D the termination of representation, and 5.3C2, bless you, supervision of non-lawyer assistance. At issue at the formal hearing was whether the respondent violated 2 rules of professional conduct, that being 8.4C, engaging in dishonesty or misrepresentation, and whether the respondent engaged in 4.1A, which is truthfulness in statements to others. In the course of the hearing, the respondent testified and exhibits were entered, and ultimately the panel found in their final hearing report that the respondent violated 8.4C, but that the burden of proof was not met in 4.1A, truthfulness in statements to others. At the formal hearing, the parties argued, among other things, disposition. At that time, the disciplinary administrator's office was requesting that the panel make a recommendation to this court for a 180-day suspension of Mr. Eland's law license, At the time, Mr. Eland was seeking a public censure. In preparing for this case before the court today, Mr. Ambrosio and I have engaged in conversations, again, preparing, seeing where we have common ground and being able to efficiently be before this court. And it's my understanding, and I'm sure Mr. Ambrosio and his client will speak to this, at this point, they are also joining in with the ODA recommendation and are not disagreeing with the 180-day suspension, and will be seeking that today. Given the procedural posture, the parties' stipulations to the facts and the rules violation, and the fact that no exceptions were filed by the parties in this case, ultimately, we're here today to determine disposition. Getting in a little bit more into the facts of the case, this was a situation where Farm & Realty hired Mr. Eland and his title company to provide title. The land and property and mineral and surface rights at question were several tracts of land in Gove County, Kansas. Historically, looking at the section of property that was sold, this land was originally procured by a gentleman named Enoch Nelson back in 1947. At some point after Mr. Enoch procured this land, he turned all of it except for half of the mineral interest rights over to another individual. Through the years following the 1940s, the individual who owned all the land, all the mineral rights, except for the half mineral interest that Mr. Enoch retained, further divided up the land between the parties and the mineral interests between several heirs and other interested parties. In 2008, the land in question and the mineral rights in question were sold at a sheriff's foreclosure sale and were purchased by a trust. In 2015, this trust went to the local realty company and asked them to assist in selling this land, but to separate out the mineral rights from the land and surface rights. It was at this point that the real estate company contacted Mr. Eland. They contacted Mr. Eland's title company, specifically contacting an employee named Mark Samuelson. Mr. Samuelson, at that point, had worked for Mr. Eland for approximately 10 years, doing title searches and assisting with title work and preparation. He performed a preliminary title search, saw a few red flags, and the parties stipulated prior to going to the hearing that he informed Mr. Eland of these red flags that he found. At the hearing, it became a little less clear whether Mr. Eland recalled whether he recalled being informed of this by Mr. Samuelson at the time. It also came out during the hearing that Mr. Eland does not check his own emails. He has staff manage his email account. The staff is responsible for reading the emails and printing off and sifting through essentially the emails, and emails that staff determines might garner a response for Mr. Eland. They print off. Mr. Eland then either dictates a response to the email or handwrites on the printed out email what he would like his response to be. And then the employee goes and writes it up and sends it off to the original recipient of the email. Throughout the title search that Mr. Samuelson conducted and the sale of the property, Mr. Eland relied heavily on his staff to handle matters. At the closing of the property in October of 2015, the parties, being the buyer and the seller and the real estate company, came to Mr. Eland's office for the closing. Mr. Eland testified at the formal hearing that he provided title assurance to the mineral rights under his role as an attorney. because the title side of his business, his title insurance did not cover or authorize title assurance being provided for solely mineral rights. So in this capacity, he was acting as an attorney, not as someone who was handling titles. Despite red flags that existed at the time of closing, he assured the buyer and the seller that good title was passing. The buyer and the seller equally split closing costs, and Mr. Eland charged a flat fee of $500 for the title opinion of the mineral rights. Shortly after closing in October of 2015, the closing of the sale, Eland Title transferred the $500 flat fee for the title opinion to be provided to Eland Law Office. Eland Law Office, rather than placing this money in the trust account, placed this money in their operating account, even though no mineral title had been provided at this time. As early as spring of 2016, the buyers were becoming concerned that perhaps what they thought of purchasing 100% of the mineral rights was not accurate, and that perhaps they just purchased less, maybe 50%, maybe more. They started contacting Mr. Eland, requesting assurance of this. And throughout the course of the next few years, Mr. Eland did assure them that good title passed despite red flags that continued to pop up. Eventually, in 2018, the buyers hired a new attorney to get to the bottom of this. Mr. Eland finally provided a title opinion on the mineral rights, stating that they purchased 100% of the mineral rights. This case proceeded to a malpractice suit. The malpractice suit was ultimately settled before trial. It was determined in the malpractice suit, as they had an independent attorney hired to conduct a title search for the mineral rights again, that the buyer only had rights to 50% of the mineral rights, not the 100% that they thought they were purchasing and that Mr. Eland assured them. This case ultimately settled through the malpractice suit. Prior to proceeding to a hearing, Mr. Eland paid out $36,000 from his own pocket, and his insurances provided $40,000 to the buyers to compensate them for what happened. These are the facts of the case, and today I stand before you and I seek a 180-day suspension in this case. And I see I am out of time, and I thank you for listening.
John Ambrosio on behalf of the respondent. I said I'd be brief in my opening before, and I will be very, very brief. The facts are contained in the panel report. The discipline suggested is in the panel report. We have no problem. My client has no problem with those suggestions, and he is willing to accept a 180-day sanction, 180-day suspension without a reinstatement hearing as suggested by the panel. He accepts responsibility for his actions in this case. And as my colleague indicated, we talked since the panel hearing. My client had visited with me and has advised me he will accept it 180 days. And let me tell you what he's done in the meantime. You'll notice in the latter part of the panel report is suggested by the panel that he divide up the law office and the title company. Now, I don't know much about title. I know less about titles than I do about, tax law. But I understand that out in that part of the country, a lot of lawyers are involved in title searches, and they're involved in title insurance and searches, et cetera. I don't understand it. He understands it. He has 4 or 5 offices around this state where he has title insurance companies. What he wants to do is he wants to turn those title companies over to his son, who now runs the office in Lawrence, and hopefully someday you'll allow him to practice law again. He loves practicing law. He's going to do 300 or is in the process of doing 380 tax returns, which would make me start drinking early in the morning. So it's a different practice out there than it is here. He's a good person. He wants to provide a service. What he's done since November is, because he knew when he read the panel report and he visited with me and I visited with my colleague, that he was going to get at least 180 days, if not more, he decided to stop taking cases. He has not taken a new case since November. In addition to that, he has divided up his title companies from his law firm. He's separated the building. He's going to have different employees. He's broken up his partnership with his law partner. His partner has taken over many of the cases that he had as a lawyer because he knew he was going to be suspended. In addition to that, he has decided that he will only be a sole practitioner. He will only take certain cases and would like to continue with his mediation. Yes,
So let me tell you what I'm bothered by, which is the lack of a reinstatement hearing. And I'm bothered by it because of the conduct that occurred trying to hide the problem. And the fact that the victims here had to file a malpractice suit, so there's denial happening before there's eventually resolution. And so looking forward to the idea of one of our responsibilities being protecting the public stated, bothered by the fact that we're not going to more closely examine that kind of denial is inappropriate and, just can't happen again. Got to be able to face problems. And we all, and in the practice of law, there are problems that lawyers create for themselves and they need to tell their clients that.
we have to admit our transgressions. I agree with you.
And I'm not even going to the transgression level. I'm just saying.
Why?
We,
Okay.
we don't hide from our clients the problem. And so I'm finding myself getting animated about that part, and the part that addresses that could be the reinstate. But just let me know why I'm wrong.
Delighted to do so. And I understand what you're saying. And we have reinstatement hearings normally where people have depression issues, issues with alcohol, have had malpractice upon malpractice upon malpractice. I can't speak for the panel. I believe that they thought he won't need a reinstatement hearing because other than this, in those two IAs 20 years ago, he's had a clean record. And I think, and again, it's hard for me to put myself with the panel and what they were thinking. They thought he was a good enough person. He had admitted he had made mistakes. I believe that they thought, and I think my colleague thinks, but she went along with that, I believe, that there would be no reinstatement hearing, that he would be a good citizen of the law if he got it back. And they thought, I think, that being slapped by 180 days and having to go through the embarrassment of going through a hearing, hiring a lawyer, having to sit on the witness stand and then show up, that would be sufficient. I'm guessing that's what it is, Your Honor. And I hear what you're saying. We always worry about that. How do you protect the public? But I think the fact that he's divesting himself from his title company and is just going to practice law, I think now he understands when we make a mistake as lawyers, when we screw up a case, when we don't show up for a hearing, our obligation is to immediately tell our clients that. I think that's what most of us have been taught to do, and all of us have done that. He didn't do that. I think he got scared, and that's a term that's thrown around. I think he became panicked about what happened, and then he circled the wagons, and I think that's the reason. And I know I'm dancing around here and being a little more animated than you were, but that's the only answer that I can really come up with. He really wants to practice law. He really enjoys it, which, as you know, I've told you many times, I have a hard time understanding. He enjoys it. He wants to serve the people in that community. He wants to do everything he can to make up for what he has. I think he's going to tell you that you will never see him up here again, that the disciplinary administrator's office we'll never see this again. I appreciate my colleagues on the other side because my colleague could have asked for even more than 180 days. Sometimes people would have asked for maybe a year suspension or so. I think the 180 days is sufficient to slap him. It's gotten his attention. That's why in November, when he got the panel report, he changed his entire business plan. He changed how he was going to run the title company. He's divesting himself of it, and he's a better person. Does 350 tax returns. They do them out there. I know.
So how does he do that
He was doing it as a lawyer. He was going to do it as a lawyer. They all,
when he's suspended?
I think by the time your decision comes down, the tax season hopefully will be over because it'll be about 4 weeks before your decision comes down and the tax season will be over. He's going to finish up most of those, but you don't have to be a lawyer to do tax returns. Nobody at tax return companies are lawyers. So he probably, if it was a longer suspension and it was into next year, he probably would do tax returns. Yes, and he will not be able to have malpractice insurance while he is suspended. So to answer your question, he would consider that. I've suggested he shouldn't be doing tax returns anyway, but no one listens to me out in Western Kansas about those things. They do that for a small amount of money to help those people out there. Hope I didn't dance too much and answer your question. Perhaps I did from the look on your face. Okay, my client, Mr. Eland would like to address the court. And I'm not being jocular about it, just that I've learned over the years, it's a lot easier to be pleasant than to fight with everybody. So that's my personality, my new personality. Come on up here, Ken. He's going to read this because he's very nervous.
May it please the court. I'm apologizing for the actions which were a violation of the code of conduct for my profession. I am truly sorry for my actions and how those actions reflect on my profession. I take responsibility for my actions and understand there must be consequences for those actions. This time has given me an opportunity to reflect on my actions. I regret each and every bad decision I made, which is why I executed the stipulations of my conduct, which were agreed upon in my case. I wish I could be judged by my 39 years of helping my clients, but I recognize I must be judged for the wrong actions I took in this instance. I have disappointed myself, but more importantly, my peers and those affected by my actions. I live in a small Western Kansas farm community where I practiced law with my father until his retirement, and I was the sole practitioner until about 5 years ago when a former law school classmate asked to join my practice. I have spent the last 6 months closing open files, and I have not accepted any new legal work in anticipation of my appearance here today. The majority of my clients are clients whom I have represented for my entire legal career, which is the nature of a small town practice. I have rarely had to terminate a client relationship, and I look forward to seeing my clients both in the office or in the community. I'm a big supporter of my community, as I believe if I want my community to support my legal practice, then I need to support every business in my community, including every community project, not only donating money, but my time as well. I was city attorney for 39 years and served as a trustee of the local hospital board for 12 years in an elected position. I've been a member of the Hoxie Rotary Club and the Hoxie Elks Lodge for 39 years, and I've served as an officer of each organization several times over. Why is this important, you might ask? For me, having been raised in Hoxie and having returned to my home community to practice law and raise my family here is truly a lifelong commitment. Before I retired last year, I refereed high school football and basketball for over 40 years. Serving the youth of Northwest Kansas most every Tuesday and Friday night, and a lot of additional Monday, Thursday, and Saturday nights. I've coached youth baseball and basketball teams for many years as a contribution to my community. Being part of a small community means more than helping my clients, but it also means helping everyone who is a part of the community, whether they're a client or not. Northwest Kansas does not have enough attorneys, and it has been difficult to turn clients away because I don't have an attorney that I can refer them to, which is the most difficult part of turning them away. I've tried to recruit new attorneys with no success because when you find an attorney who wants to choose this lifestyle, their spouse does not. I don't know how to not think of myself as an attorney. It is my identity, and I am very proud of the help that I have given my clients in the past. I'm very sorry I am appearing in front of you today and only wish I had not made some of the very bad choices in this situation. I can only say that throughout my life, I've made many mistakes. But most importantly, I feel that from those mistakes, I have learned from them and can move forward a better person and hopefully a better attorney for my clients. I will never be perfect, and I can only strive to be the best I can be. I'm asking that my license not be revoked. Being an attorney is a privilege, not a right, and as such, I hope you can see fit to allow me to continue to practice.
Not mean by the last remark that he was not accepting the 180 days. He just doesn't want it longer than that, I think is what he's asking.
Absolutely.
Sorry.
Questions of either? Thank you. Art, you reserve 3 minutes.
Madam Chief Justice, Justices, I don't believe that I have anything specifically that I need to address on rebuttal unless the court has specific questions.
Thank
Thank
you.
you.
Thank you to all of you for your comments and arguments today. We will take this matter under advisement.